Judge, thank you. Just a real quick thing. The court had asked at our sidebar, I think our last sidebar, about a particular piece of evidence, if you recall, and I indicated it was in a lab report. I just wanted to provide that to the court and showing Mr. Hospica's Exhibit 91. And I believe it's the first item, Judge.
So, Mr. Hostica and Mr. Hilson, can you please approach? Yeah. One more. Sure. That's okay.
Judge, obviously we've gone through just about 3 days worth of testimony, so I'm moving the court to bind this case over on both counts, and I'll give the court some of the highlights here as to why I think we've proven to be a probable cause that the crimes were committed and that the defendant committed both of these crimes. First and foremost, as it relates to the kidnapping charge, we know from the testimony that was given in this courtroom that there's a very small window of time. That Susan Mosley purchased a lighter with Jessica as a cashier on April 26, 2013 at 10:52 p.m. And we know that Craig Harpster came to the Exxon Mobil station about 11:07 p.m. to find nobody there. So we have a very, very small, and as the court has learned through Lieutenant Casher's testimony, we have a video from the mattress store, which is kind of on the corner of the mall in Old Grand Haven, with this silver van turning right onto Old Grand Haven about 11:04 p.m. So a very small window of time. We do know from the officers at the scene that Jessica left her purse with its contents, left her coat, and left her car. We also know, Judge, that the cash drawer for the Exxon Mobil station was undisturbed. So nothing else was taken except for Jessica. We know from a few witnesses, Dakota, that Jessica has not contacted Dakota, who is in the care and custody of their son, since 2013. We've had zero contact. I think indirectly, Judge, the court can take notice of this fact that had Jessica reached out to mom or grandma, we wouldn't be here today. That we would have information of where she is and that she's doing fine. And certainly, with the last witness, Ms. Lunsford, given the history that those two had together, the relationship that they had together, it's her opinion that if she were alive, she would have reached out to her over these last 3 years, and that has not happened. We do know that outside the back door, which is an area that was sometimes used by Jessica to take breaks, whether it's smoke breaks or talk breaks or whatever, that they would hang out in the back. We do know that there was definitely a sign of a struggle. We have a blood spot, which has been determined to be Jessica Heeringa's blood. In the vicinity of that blood spot, we have 2 watch batteries and a laser sight cover to the gun, and we'll get to that in just a second. What's important about that particular piece of evidence is the testimony of Gary Foster that indicated that it would take some force, some violence in order to pop that cover loose. Whether it be, as he indicated, probably the force of dropping the gun from the ready position, if you will, down to the ground. But some force causes that cover to come loose, and certainly the blood at the scene, I think, strongly suggests that. The defendant's involvement. He knew Jessica. He admitted that he knew Jessica. He admitted that he goes to the Exxon station. And it makes sense because his work, Herman Miller, is right in the direct line of path, if you will. I mean, Herman Miller is down the street from that area. We know that he works third shift and he works at night. We know that he owns a silver minivan. And we know that he had purchased that silver minivan a month prior to her disappearing. The other piece of important evidence, Judge, is People's Exhibit 87, which I think is over there. But 87 is a photograph taken from the Willis household where it shows he owned a bright orange and a bright red shirt. And that's important based on Susan Follett's testimony, that she recalls seeing the white male individual wearing a bright orange and a bright red shirt as the silver van drove by them. We know that on April 25th of 2013, through the testimony of the HR person from Herman Miller, that he took the day off, that being the defendant. And from the testimony of Brenda Nestor, that on that particular night, after she had dropped off and was waiting to pick up her friend from the big game room, she walked into the Exxon station, saw Jessica working, and saw the defendant there as well. And regardless, her feeling was that the situation called for her to basically say, look, I'm going to stick around until you close up just to make sure you're safe. And as Ms. Nestor testified, she sat and watched and waited and saw the defendant get in his silver van and drive down the service drive, take a right on Old Grand Haven Road and head north. And the other piece of very significant information that helps corroborate Ms. Nestor's story is this, is that Sergeant McDonald's testimony of the cell phone records, at 12:36 a.m. on the 26th, so that would be after Ms. Nestor sees the defendant, his phone is pinging in an area that includes 3038 Valley, which, as we know from the testimony of Lieutenant Casher, if you're heading north on Grand Haven Road, that is a direct route to that house. We know on April 26, 2013, the defendant admitted to investigators that he did, in fact, go to the Exxon station about 5 p.m. My view of that piece of evidence is that he was checking to see if Jessica was working that night. We do know that he did stay in the area then. This magic tournament, this card game that was going on. We know from Carl Warr that he saw the defendant on 2 occasions. Even though he was playing poker at the big game room, he went down and was kind of seeing what was going on. He saw the defendant on 2 occasions, and we know from his testimony that those games usually ended, in fact, the owner made sure they ended right around 11 o'clock, again, putting him in the area at the time of her disappearance. Then we have the testimony of Ms. Follett and Mr. Barber. As they're driving their motorcycles along Sternberg Road, they see this silver van, and they notice that it does kind of a U-turn in the Exxon lot, and as it's coming back around, it cuts its lights and drives to the back of the Exxon Mobil station. Both witnesses, when shown pictures of the defendant's van that had been seized by officers, indicated that that van was consistent with the van they saw that particular night. Further, we know from Ms. Follett that she saw the van parked with its nose kind of sticking out of the side of the building. If you recall her testimony, Judge, she said as they were making the turn, coming back and turning on the service road, she could already see the end of the van sticking out. Which again, if you put that in concert with where the batteries and the sight cover were found, that puts the back of that van right at the back door. They also, Ms. Follett also testified about seeing, as they were kind of making their way up the service drive to eventually where they parked in the parking lot, Ms. Follett also testified seeing some movement in the back. She couldn't see because the hatch of the van was up, but saw some movement happening in the back. Both of them see the van hatch go down and immediately pop up, which suggests that something was blocking the latch itself, not allowing it to close. And what's also significant is as the van drives by them, they see one white male driving, and they describe no other movement, which would suggest that Jessica was subdued in some fashion and was not moving. They also testified that they were right behind the van as it turned north on Old Grand Haven Road. And again, as we've heard from Lieutenant Casher today, we have video of this silver van as it makes its way north, going from the mattress store to Old Homestead, past Boyer Coins, again putting that van in the vicinity and area with 3038 Bailey. The other significance, certainly, that the court heard is the phone records. On 4 occasions, between the late night of the 26th and the early morning of the 27th of April, the defendant's cell phone is pinging in the area of where 3038 Bailey was. And what's significant about those phone records, it's not like he was receiving a call from some random person. It was his house calling him. I'm sure his wife trying to find out where the heck he was. Because again, Friday night was his normal night off. So that ping happens at 11:23 p.m. on the 26th, 11:59 p.m. on the 26th, midnight on the 27th, and 12:05 on the 27th. And what's significant about that is the testimony of Corporal Hare, who interviewed the defendant 2.5 weeks after the abduction, and was told by the defendant that on that particular night, the 26th, he was home from 9:30 until 12:30 a.m. the next day. And then at 12:30 a.m. he decided to get up, go to the house on Bailey, and get a piece of wood to help build a doghouse. We know that that's not true. The phone records prove that he lied to the officers. The gun, Michelle Schnatola, co-worker of the defendant. Records were introduced. She testified, Mr. Foster testified, that when she purchased that gun in May 1st of 2012, she purchased it with a laser sight. That it was an actual attachment to the gun when it was purchased. And as Mr. Foster described to the court, the laser sight found at the scene at the Exxon Mobil station would be the laser sight cover he would expect to find on that particular laser sight. We know from Michelle that she only fired the gun a couple of times, wasn't an avid gun user. That we also know from the Computer Crimes Unit that this defendant in December of 12 was searching for information on Walther guns. We also know after that, on April 1st, so 25 days prior to Jessica's disappearance, he's on the Walther Arms website looking at accessories or products for handguns. We know from the testimony of Michelle that in early March, she discovered snowmobile tracks by her house and actually asked the defendant about that the next time he came to work. And the defendant admitted to her that he, in fact, had been by her house and had driven his snowmobile around her house. What's curious about that, Judge, is that that time frame, as the HR director pointed out, was the time frame he was off of work and Michelle was working. And we know that's significant because, as Michelle indicated in her testimony, that when she wasn't out of town. In other words, she wasn't going out of town for an extended period of time. She left her house unlocked. And more importantly, she kept her gun in the closet in the same area where her laundry basket was. And that's significant because we know from her testimony and from the testimony of the officers involved that 2 pairs of underwear were found in a shed at 1842 South Sheridan. DNA says it's hers, and she says, those are my underwear. And there would be no reason why the defendant would have those. She did not give them to him. She never would have given him any article of clothing, and there's no reason why he should have possession of that. The significance, Judge, obviously is this, because not only do we find the underwear, but in the van itself we find this Walther P22, her Walther P22. Even though the defendant attempted to obliterate the serial number, he apparently was unaware of the secondary serial number, but the MSP crime lab was able to restore the first. And we know from that restoration and the records from Gary's guns that that, in fact, is the gun that Michelle Schnatola purchased back in May of 2012. We know that he's handled that gun because his DNA is both on the grip and the trigger. And what I find also significant, Judge, is this, is that they find what appeared to be the presence of blood on the interior barrel, so the slide. And that's significant for this reason. As the court evaluates the evidence in this case, in particular, when I get to this part of it, the evidence of MJN and the significance of finding 2 long rifle .22 caliber bullets at the scene where she jumped out of the vehicle. And there's a lot of talk about racking a gun and whether or not you could hear it and whatnot. But to me, the significance of finding his blood in the interior is that if you're panicked and you're in a hurry and you're racking that gun, guns are sharp, they're metal, they can easily cut. To me, that's a significant find by the Michigan State Police. On top of, obviously, the gun being found in the van that's registered to him that he was driving that night. Why is Jessica dead, and why is she dead via criminal agency? Well, I go back with the no contact with Dakota and the son, no contact with the family, no contact with Liz Lunsford. Mr. Barron's testimony, I think, is very significant. The Sunday after Jessica goes missing, he sees the defendant. He observes scratches on his arm, a deep scratch cut on his hand, and scratches on his face. When asked, the defendant offers the explanation that he got these injuries by working on his brakes, but showed no other signs of working on a vehicle. No grease, no grime, no nothing on his hands and fingers. His habits, Judge. The serial killer list, again, found in that shed. The kit list that was read by Detective Sparks found at Bailey in the garbage can. That kit list containing a lot of elements that we find in the defendant's van in that locked toolbox. Certainly the abduction, rape, kill videos, the hundreds that were discovered by Mr. McCarthy. And what's significant about that, Judge, and the court has, and certainly if the court wishes to see the exhibits, I'll offer to the court, but what we find in that box is restraints, rope, chain, handcuffs. We find ball gags, things, we find rubber gloves, all that was part of the video collection that Mr. McCarthy observed as he looked through those hard drives. Certainly the significance of the changing of passwords. I think that cannot go unnoticed, that in 2010 he had relatively innocuous passwords, yet in 2015 7 of those passwords changed to Jessica Heeringa's initials and the date of her death and disappearance. I think that's significant. Also the Vic folder. That to me is a big piece of evidence. That in that Vic folder, the 2 subfolders, one containing Rebecca Bletch and her date of death, and one containing Jessica Heeringa and her date of disappearance and death. We know for a fact that Rebecca Bletch was killed. We have that body. We know that she died at the hands of criminal means, 3 gunshot wounds to the head. And the defendant incorporated her, Miss Bletch, with Jessica Heeringa. I think that's very significant. And we know the defendant's connection, at least for this particular exam, to Rebecca Bletch based on ballistics. In other words, the handgun found in the car, the van that the defendant was driving. comes back matching both ballistically by the bullets that were retrieved from Rebecca Bletch's head and the shell casings retrieved from the scene. It was that gun that fired those kill shots. Most importantly, Judge, we know from the DNA evidence that the substance found on the Reebok glove, which was contained inside that locked toolbox, is 90 quadrillion times more likely the DNA profile of Rebecca Bletch than any unrelated person. 90 quadrillion times more. Her DNA profile on that glove. The significance of MJN in that whole scenario as it relates to whether or not Jessica is dead and whether or not she died as a result of criminal agency. MJN being lured into the defendant's van via a lie. The only way she was going to be able to use his phone was to basically get in the car, which is exactly where he wanted her. The fact that as soon as she got in the car and asked for the phone, he said the phone was dead. The fact that even though she wanted to go in one direction, he went in a different direction. This idea that, as she described it, it appeared as though it was a black gun with an orange cap. And we know from the investigators that the evidence guys that were part of collecting evidence at all the houses, including the car, there wasn't a single orange-tipped gun found. There wasn't a single toy gun found. There wasn't a fake gun found. But what is significant, Judge, is that when we look in the van, we find orange-tipped syringes with what appears to be insulin. And the other significant part, Your Honor, is on the underbelly of the toolbox itself, a diagram labeling injection spots as to slow, medium, fast response. Obviously, well, I believe the evidence suggests that what MJN saw and what she was going to be subject to and what Jessica Heeringa was subject to was a shot of insulin to knock her or render her either unconscious or essentially immobile. That, to me, explains the orange cap. Finally, Judge, we have the .22 caliber bullets. Not only, as I indicated already, at the Rebecca Bletch homicide scene, but the .22 caliber bullets CCI manufactured at the MJN abduction, the .22 caliber CCI bullets found within the contents of the van that the defendant was driving. To me, what that adds up to, Judge, is this, is that the defendant's method of operation was he was not leaving any of his victims alive. That's true with Rebecca Bletch. That's certainly true. I suggest to the court via probable cause that it's true with Jessica Heeringa, and that certainly would have been the case had the gun not malfunctioned for MJN. There's no question that the evidence suggests and shows that the defendant was attempting to shoot her because she was running and escaping. He keeps no victims alive. For that reason, Judge, it's the people's position that not only is the defendant involved based on what I've already highlighted, and certainly the court has taken great notes in what the court has, but also that Jessica is dead and she died as a result of a criminal agency. For all those reasons, and certainly the other evidence that the court has heard, I'm asking this court to bind this defendant over to circuit court on both counts, the kidnapping and the open murder charge. Thank you.
Mr. Hostaker.
Your Honor, the majority of this hearing has been about other acts and unproven allegations against Mr. Willis. There is no direct evidence tying him to the disappearance of Jessica Heeringa. We've heard evidence about Rebecca Bletch getting shot from behind in June 2014. We know that there's a minor child that accuses Mr. Willis of pointing a gun with an orange tip at her. None of these things has any connection to the disappearance of Jessica Heeringa. That happened over a year before the more latter of the two, which is the Bletch case. Now, you allow these other acts under Rule 404B primarily for two reasons. One was under a theory of common scheme or plan. There's nothing common about these three, other than I think you cited in your reasoning that they involve women in Muskegon County. That's really it, Judge. Rebecca Bletch was shot from behind while she was out jogging one day. There is no evidence that there was any attempt at an abduction. In the prosecutor's brief, I think in support of admitting this evidence, they argue that there's blunt force trauma, which shows evidence that there was an attempted binding of somehow. But on the testimony that was elicited at this hearing, any blunt force injuries that were on her body, the doctor that did the autopsy believes were caused when she fell after she got shot. No evidence of any attempted abduction. The minor child was picked up on River Road. She was out partying, drinking, smoking marijuana all night. She outlasted everybody at the party, and she took off on foot. She said she walked 4 or 5 hours, which, knowing the path that she took, Your Honor, is probably an exaggeration, but there's no doubt this girl was exhausted. There's no doubt that she was distraught. She was happy when somebody stopped to give her a ride. She willingly climbed in. She was relieved when the driver of the car rolled the window down. And then, she says, the driver pointed a gun with an orange tip at her. She immediately yells, "Stop." The driver slows down. She jumps out, and then starts running. Okay? That has no connection to Jessica Heeringa's case. None. The prosecutor, she didn't get shot, and she didn't get abducted. That's not an abduction either. Now, you also allowed this evidence under a theory, I think, of the doctrine of chances, based on the fact that the prosecutor insists that a gun was involved in the same 3 cases, the same gun. We don't know that. We haven't heard evidence to that in that regard. We've heard evidence connecting a Walther P.22 that police say they found in Mr. Willis's van to Mrs. Bletch's death through ballistics. Now, I know the court's position as to ballistics being a science. In fact, the defense strongly disagrees, and I think we're supported by the majority of courts in this country. In fact, the ballistics expert that testified said it's a subjective science. That's an oxymoron. Our position is it's not a science at all. It's looking at 2 pictures and just trying to decide what's the same and what's different. But that's beside the point. That's one gun that was their expert, or ballistics expert, alleges was directly tied to what the evidence was found at the Rebecca Bletch scene. The minor child said a gun pointed at her had an orange tip. The Walther P.22 does not have an orange tip. They try to clear this gap, fill this gap, by saying these 2 misshapen, wholly corroded, weathered 22 bullets that were found nearby somehow came from Mr. Willis. At the same time, they say that we've seen pictures of bullets allegedly found in his car that are very shiny, well organized, and brand new. The fact is, Your Honor, somebody was out in rural Muskegon County sometime before this playing with the 22. And these old, corroded bullets were left behind. It has nothing to do with Mr. Willis. And with Ms. Heeringa's case, there's a laser cap found. A laser cap to a cheap, easily accessible accessory for these types of guns. Common. I think the owner, Mr. I think it's Foster, I can't remember his first name, Gary's Guns, thinks he sold maybe 30 of them in that year, and they can be fitted onto other guns. So trying to draw the connection between the 3, saying it's the same gun, just doesn't fly. Your Honor, the only thing Rule 404B does is exactly what it purports not to do. It prejudices the trier of fact against a defendant based on unproven allegations of other things. That's all that this did. So what do we have? The police say they found items that they would say makes up a rape kit in Mr. Willis's van. A ball gag, vibrators, restraints. None of them had Miss Heeringa's DNA on them. None. Some of them had Mr. Willis's wife's DNA on them. There's no evidence that these things were used on anyone by Mr. Willis, except his wife. Now, granted, there was evidence that came out that said Mrs. Bletch's DNA was found on a glove in the car, but that's something that's going to be thoroughly litigated and challenged in court at the time of trial, which hasn't happened yet, obviously. But regardless, it has nothing to do with Jessica Heeringa. There's syringes and a diagram of injection sites on a woman's body. And there's also insulin. Well, Mr. Willis's wife is diabetic, and she requires insulin injections.
Injection. There's no evidence that she requires injections. There's evidence that maybe she requires insulin, but not how it's delivered. I don't recall any testimony of that.
She requires insulin, Judge.
I don't know that there's evidence of that. I do recall you questioning a witness on cross-examination. Are you aware that Charlene, I want to get the name right, is it Charlene
Yes.
Willis, is a diabetic?
Right.
And I think the witness said, I'm not sure.
And he said he heard that.
What's that?
He said he had heard that.
Okay. I don't know that, some diabetics take pills, some diabetics don't take pills. They manage their diabetes through diet. Some, on the grand scheme of things, there's a lot of different things that diabetics can do. But you can argue reasonable inferences from facts as well, Mr. Mustica. So
thank you.
I'll just like Mr. Hilson's using circumstantial evidence, you are doing the same right now.
Exactly.
So I'm going to allow it. Go ahead.
Thank you. Now, Mr. Willis's van was searched about 3.5 years after Miss Heeringa's disappearance. There is no evidence that any of this stuff was in his possession at the time. In fact, there's evidence that it wasn't in his possession at the time, because of that list found at the very top of a garbage can in Mr. Willis's grandfather's garage. Had the items that are found in his van written on them. That list wasn't sitting there for 4 years. That list, if anything, shows that these things were recently obtained. The police say they found horror porn, if I may call it that, on Mr. Willis's computer and a list of serial killers in his shed. It's repulsive to many, a fetish to some. Doesn't have anything to do with the disappearance of Jessica Heeringa. Doesn't prove it more likely or less likely. The stuff came from the internet, where anything could be found. These were fictional depictions. None of it was taken by Mr. Willis, created by Mr. Willis. None of it featured Miss Heeringa, or had anything to do with Miss Heeringa. Or Mrs. Bletch, or the minor for that matter. The police say they found a file with Miss Heeringa's initials and passwords for Mr. Willis used that they connect to Miss Heeringa. Okay? And there's also a file with Mrs. Bletch's initials. Unsolved cases in Muskegon County. There's pictures in the files of each of these two women, or pictures of people resembling them, and there's news articles. All of it came from the internet. None of it taken by Mr. Willis. And certainly, when you remember that the police actually went out and questioned Mr. Willis in May of 2013 about the Heeringa case, you can understand his fascination with that case and keeping an eye with what's going on. No pictures or videos of Ms. Heeringa, despite the police saying that 2 video cameras found in his van were part of this rape kit and this plan. Okay? Obviously not in that case. You would expect it if that was true. Now, what I think is the real evidence. Woman, Miss Nestor, says she saw Mr. Willis at the Exxon station the night before the abduction. This woman is incredible. She thinks what she saw made her fear for Miss Heeringa because a shudder ran up her back, or something like that. So she sits out in her car and she watches to make sure she's okay. The next day, it's all over the news that Jessica Heeringa disappears. She does nothing. For 3 years, the news goes on about the dead end and the search for Jessica Heeringa. This woman sees her with a man the night before that she thinks Jessica's afraid of and watches out for her. And that's not news that could break the case? And she tells nobody? She never reports it to the police? And what's more, despite Lieutenant Casher's efforts to dodge and make excuses, Jessica Heeringa wasn't even on the Exxon schedule to work that night. So, I think she wants her 15 minutes of fame. I think she got it. She's not credible. It didn't happen. There's evidence that Mr. Willis was at the game room playing card games that day that Miss Heeringa disappeared. He freely admitted it. When the police came to his house on May 5th, or whatever it was, May 8th. Yeah, he was there. Yeah, he stopped at the Exxon station. Yeah, he knew Jessica Heeringa. He cooperated with them. They wanted to search his van. Search my van. 3 years after, Corporal Hare takes the stand and testifies that the van is vacuumed out and smelled of cleaning product. Doesn't write a report until less than a month ago, or about a month ago, 3.5 years later. Says the van was recently detailed. That van hadn't been detailed. That van hadn't been detailed until June 12th of 2013. When Lieutenant Casher spoke with Charlene Willis, when she was at the hospital, for whatever reason we didn't get that, but why she was at the hospital, that is, which isn't relevant to this anyway, but she told him they got the van detailed one time since they bought it. And that was June 12th. That was over a month after that officer came out to question them. So there's something wrong there. The recollection that it smelled of cleaning powder and was recently vacuumed, and that, in particular, that it had been detailed, that's not true. So there's something wrong with the memory, something wrong with the passing of information from the note pages to the basket to the guy that enters it electronically back to Corporal Hare, who 3.5 years later types it into his report, which happens to be almost identical to the report that his partner, Officer Baker, wrote regarding the incident. Almost exactly the same. But he cooperated. The next day, he brings in his phone, and it worked. He dropped it off at Norton Shores, and it worked. It stopped working while they had it. We know someone creepy was hanging around the Exxon station, according to Miss Mosley. So she reported it to Exxon, the management. But it wasn't Mr. Willis. Miss Lunsford made a mention of something similar to that, too, that fits in the time frame. But it wasn't Mr. Willis. She's never heard of him. She's never seen him. She hung out with her there frequently. There's a drop of blood outside the back door of the station. Miss Heeringa's blood. The police responded quickly to the scene after the call went out. By the time Corporal Hooksema saw the blood spot, it was a dried blood spot. We don't know how long that blood was there. We don't know where it came from. He had to use a swab with distilled water to scrape up some of the dried blood to send it on to the lab. We know Miss Heeringa used to hang out the back door smoking with her friends. We don't know how the blood got there. There was batteries and a laser sight found at the scene. I've already talked about that. These are cheap and apparently common .22 accessories that cannot be tied to any particular gun. Miss Mosley bought a lighter at 10:52 from Miss Heeringa. She's the last person to see her. Mr. Harpster arrived at the station at 11:07, 15-minute window there. Further narrowed by video from apparently the mattress place of the silver van taking a right turn to go north on Grand Haven Road. 11:04. 12 minutes. Further narrowed by Miss Follett and Mr. Barber, saying that they pulled into they saw a van pull behind the station a few minutes before 11. So we're talking less than 10 minutes. What they saw, what they both testified to, was that they thought they saw a Chrysler Town and Country. May I approach and see the exhibits, Judge, that I had submitted earlier? Thank you. Lieutenant Hare, or somebody in the task force, contacts Chrysler and says, look at these videos of this car. And they continue their search, limited to Chrysler Town and Countries. One can only assume Chrysler identified that as a Chrysler Town and Country. Mr. Willis drove a Dodge Caravan. Miss Follett saw the person who was with the Chrysler Town and Country in the back of the Exxon station that night the best. She saw a tall man with pretty blonde hair and no facial hair. Twice, sketch artist with the police department drew who she described. And these are the pictures, Judge. And this isn't Mr. Willis. Not by any stretch. We know that he had facial hair at the time. The hair is different. There's no facial hair. Younger. It wasn't him. Your Honor, I'm asking you not to bind over Mr. Willis. I object to that bind over. I think this entire presentation over these last 4 days has been a showing of all this other evidence that Mr. Hilson thinks someday he's going to prove against Mr. Willis. He hasn't even had a chance to defend himself in a court of law on any of those charges. But there's nothing with the Heeringa case. It should not be bound over. We don't know what happened to her. We do know that she had some troubles. She was going through a difficult time. But she remains missing. We don't know what happened. To infer that Jeffrey Willis abducted and killed her is a leap that this court should not take. So I ask that this case be dismissed, Your Honor.
Thank you, Mr. Hunt.
Return your exhibits, Your Honor.
Thank you. All right, in making its ruling, the court is cognizant of the purpose of a preliminary examination, and those purposes are defined in Michigan Compiled Law 766.13, as well as Michigan Court Rule 6.110, subsection E. The purpose of a preliminary examination is to determine whether there is probable cause to believe that a crime was committed and that the defendant committed it. And that is an established standard that I am to follow and will follow. The charges against Mr. Willis involved in this complaint involve count 1, homicide, open murder, in that the allegation is that Mr. Willis did on or about April 26, 2013 in the city of Norton Shores at or near 1196 East Sternberg, that he did murder Jessica Heeringa, contrary to MCL 750.316. The second count is that at the same time, date, and place that Mr. Willis did commit the felony offense of kidnapping, and that he did knowingly restrain Jessica Lynn Heeringa with intent to engage in criminal sexual penetration or criminal sexual contact with that person, contrary to MCL 750.349. I'm also cognizant of the following cases, and I'm guided by our Supreme Court and our Court of Appeals in this regard. I have reviewed the cases of People versus McMahon, that's spelled MC, capital M-A-H-A-N, at 451 Michigan 543. That's a 1996 case. I have reviewed People versus Brasic, that is B-R-A-S-I-C, at 171 Michigan Appeals 222, a 1988 Court of Appeals case. I've also reviewed People versus Modelsky, that's M-O-D-E-L-S-K-I, at 164 Michigan Appeals 337, a 1987 Court of Appeals case. I've also reviewed People versus Williams, common spelling, at 422 Michigan Report 381. It's a 1985 case. What the court is bound to follow is the standard articulated in the Modelsky case, previously cited at page 342. The Court of Appeals, after analyzing the corpus delicti rule, indicates the following, quote, "From the above authorities, we conclude that the corpus delicti of homicide is established when the prosecutor establishes by a preponderance of direct or circumstantial evidence that the victim is dead and that the death was the result of some criminal agency." Now, these cases that I've cited all analyze the corpus delicti rule, and I'm cognizant of this, from the standpoint of the admission of confessions. But I'm guided by these cases in applying a standard of law to the prosecutor's burden of proof at a preliminary examination that, one, Jessica Lynn Heeringa is dead, and two, that that death was caused by some criminal agency. Now, the Modelsky case articulates the standard as being a preponderance of evidence. I believe the standard is somewhat lower, and that is probable cause, and some people would say those are synonymous. But I am guided by MCL 766.13, and that is a standard put on the court that says, one, the court's got to find there's probable cause to believe that these crimes alleged in these felony complaints were committed, and two, there's probable cause to believe that Mr. Jeffrey Thomas Willis committed those acts. So I am analyzing it from the standpoint of the statute and its case law, but also under the cases that I've cited that say the prosecutor's got to establish by a preponderance of evidence, direct and circumstantial, or a combination thereof, that the victim is dead and that the death was the result of some criminal agency. The McMahon court summarizes the Modelsky, Brasic, and Williams cases, and that's a Supreme Court decision, as I said, from May of 1996, And in analyzing those cases, the Michigan Supreme Court found important in the Badelsky case, in the Brasic case, that the victim was last seen with the defendant, and thus in the Brasic case there was evidence that the defendant had acted violently toward the victim just prior to her disappearance. And the facts of Brasic show some violence between the victim and the suspect, in that case the defendant, Brasic. And again, citing the McMahon case at 552, finds it important to note that in the Badelsky case, there was also evidence of violence between the defendant and the victim, and found relevant the defendant's actions after her disappearance. And in that regard, those actions helped establish the corpus delicti of the offense. And I'm bound by those cases, and I'll follow that law. In deciding this case, the court is considering the totality of evidence that was presented over the last 3 days, and I have reviewed my notes. I did my best to pay attention every minute. I'll commend the lawyers on a well-presented preliminary examination. But I will also just highlight some of the facts that I think are necessary and important for my decision. But I want the record to reflect I'm considering the totality of evidence here, and I'm considering that evidence as a whole, taken together. The court does consider the testimony of Brenda Nestor. She indicated that she was a customer at the Exxon station, had been in the Exxon station the night previous to the abduction, that would be Thursday night, and that Mr. Willis was in the store. And to me, that is important circumstantial evidence, along with everything else, that the defendant had at least peripheral relationship with Jessica Heeringa and was discussing things with Miss Heeringa and had spent time with her in the store, and that he was with her the night before the alleged abduction and murder. I'm finding it important circumstantial evidence that Miss Nestor felt it important enough to stop and wait in the parking lot and watched Mr. Willis leave in a silver minivan. And I also find it corroborative that Ms. Nestor identified the path of travel of Mr. Willis that night, and that was that he took a right on Sternberg and then a right on Grand Haven Road, the same alleged path that Ms. Follett and Mr. Barber observed the silver minivan take the next night. And I'm finding that to be circumstantial evidence that the court is considering. And I also note for the record that Ms. Nestor identified positively Mr. Willis from that contact the night before. As to the corpus delicti, I am finding it important to note that Dakota Dreyer, and I hope I'm pronouncing his name correctly, Dakota Dreyer, the live-in boyfriend of Jessica Lynn Heeringa, indicated that not only did he live with her, but that he lived with Miss Heeringa's 3-year-old son, that they grocery shopped together, that Miss Heeringa operated the Mercury Sable, the burgundy Mercury Sable that was presented in one of the People's exhibits, took that to work with her, and that the relationship between Jessica Heeringa and her son was categorized as great. I'm also finding it important to note that Mr. Dreyer noted that Jessica Lynn Heeringa's coat, purse, wallet, and money were all still at the gas station upon her leaving. And the Mercury Sable was all still left at the gas station. It's inescapable to me how on April 26th of 2013, if Miss Heeringa left of her own doing. She didn't take her purse, didn't take her money, didn't take her coat, didn't take her car, didn't take her cell phone from the car. She took no personal effects with her that night. That, to me, doesn't make any sense. To me, that is circumstantial evidence that Ms. Heeringa left unwillingly, coupled with things that I'll get to in a moment. Mr. Dyer testified that he was aware of Ms. Heeringa having one phone, but on cross-examination it became clear that there was a second phone found in the car. Why Ms. Heeringa wouldn't take that phone with her if that was a phone that she had in her car, if she left voluntarily, to me is unexplainable. The court's considering the testimony of Susan Mosley, and I find that Ms. Mosley, a credible witness in this court's mind, stopped by the gas station periodically, was familiar with Ms. Heeringa, and on this particular occasion she purchased a lighter at 10:52 and was certainly one of the last persons to see Ms. Heeringa, and that was at 10:52 p.m. She said she left within a minute or so of that purchase after a few just minor exchanges of words. That Ms. Heeringa chatted and was in a good mood, according to Ms. Mosley. Not of a state of mind in this court's estimation, which would evidence somebody abruptly leaving work without closing the store, without turning the lights off, without taking her purse, her wallet, her coat, her money, any money from the store. The cash register till was left intact. If she's going to escape and leave and just vanish from the face of the earth here, she would take some money with her. It's certainly her own money, but it could be argued that she'd take the store's money if she's going to leave the store wide open. None of that was done. The cash register looked as if it was ready for closing. The court's considering the testimony of Susan Follett and Eric Barber. With respect to Mr. Barber, he indicated that he saw the silver minivan pull into the lot, shut its headlights off as it was turning the northeast corner of the Exxon station. To me, customers at the Exxon station park in the front or at the pumps, not in the rear of the store where there's no parking spots. And it is, in my mind, not the most important piece of evidence, but it certainly, in my mind, does support some nefarious conclusions that the vehicle is pulling around the back of the store with its headlights off. And that was confirmed by Ms. Follett. Mr. Barber indicated that it was his opinion that something looked quote-unquote fishy, to use his term. He and Ms. Follett went up to the next corner at Sternberg and I believe Harvey Street, that the Bell Tire circled around and came back, and watched the minivan at the back of the store and saw an individual open the back hatch, close it, and then open it again and close it again. What's also important in terms of the corpus delicti of this crime, circumstantially, is that Mr. Barber indicated that as he saw the minivan pull out through the service drive heading west towards Grand Haven Road, that he saw no one else in the van. And we know from the evidence that within minutes thereafter, Mr. Harpster's at the store and there's nobody in the store. Ms. Heeringa is not there anymore. So it's within that time period that Mr. Hostica outlined, I believe that 12-minute time period between 10:52, I believe, and 11:04, that these crimes were at least started. But it's important for me to note that there was no one else in the van or no other movement in the van other than the driver of the van. And we know Miss Heeringa wasn't at the store when Mr. Harpster got there. And if Miss Heeringa was in the van willingly, she'd be in the passenger seat. Mr. Barber articulated on the record through direct examination that he thought the silver minivan was a Chrysler Town and Country with rims that looked similar to, I believe, a family member's. The court notes that the vehicle Mr. Willis was ultimately stopped in and identified as being his vehicle is a Dodge Caravan. Can't be unnoticed that Dodge and Chrysler are the same company, similar to the old Pontiac Firebird and the Chevy Camaro. They looked awful darn similar to me when I was a kid. Similar to a Chevy pickup truck and a GMC Sierra pickup truck. Same manufacturing company. Very similar in its appearance. And this is was described as a Chrysler Town and Country. The ultimate vehicle owned by Mr. Willis is a Dodge Caravan. Again, Susan Follett testified that she saw the silver minivan make a U-turn in the lot and go to the back of the building, turning its lights on. And after the described opening and closing of the hatch, she says that the minivan pulled away, quote unquote, so quick. And she didn't see anybody in the passenger seat. And she identified People's Exhibits 10, 11, and 12 as being consistent with the van that she saw. She identified that night. And again, she said the only other vehicle she saw there was Jessica Lynn Heeringa's Mercury Sable, and that was photographed by law enforcement that night. The court's considering the testimony of Craig Harpster. He indicated that he, after pulling up to the pump to get gas, it was on empty, that he saw no one at the store. He entered, hollered for somebody, looked around, looked behind the counter, walked in the cooler, looked out back, and saw a purse near the cash register and a coat. And again, I'm finding that that's significant evidence in this court's mind as to the finding of corpus. That's supported by the testimony of Corporal Joel Huxema, who indicated that Ms. Heeringa's coat and purse as an employee of the store were left there, and that the cash drawer was left on the safe and the money was not disturbed in the cash drawer. Again, that's significant to me, given what I've already said. If Ms. Heeringa is going to voluntarily leave, she's going to take her personal belongings and some cash and her purse and her identifying documents. Also significant to me is Corporal Huxema's testimony that there were two small watch-sized batteries found, the battery cover for a laser sight found at the rear of the store, and that this was near a blood stain. And that blood stain was ultimately, by stipulation, identified as belonging or having a DNA consistency consistent with that of the blood of Jessica Heeringa. and that the courts reviewed People's Exhibit number 9, the photograph of the battery cover on its back cover listing in the words Carl Walther, and that battery cover having been identified as coming from a laser sight belonging to a Walther handgun. The court would note that this is not a drop of blood. This is a blood stain described as being 2 to 3 inches in size, and it appeared to be a smear, which in my mind is different than a drop, and it, in my mind, is consistent with blood drawing much quicker than a drop of blood. And its relationship to the door, the north door, the blood stain, the 2 small watch-sized batteries consistent with batteries found to be used in the laser sight and the laser sight cover all within feet of the north back door of the Exxon station. The court finds it significant to note that Corporal Chris Hare interviewed the defendant on May 7th of 2013 or thereabouts, and that he had contact with the defendant at his front door. He said he was alone. He admitted that he frequents the Exxon station and that he was there on April 26th of 2013. He admitted that he did know Jessica Lynn Heeringa. I find the following statements and the previous statements attributed to Mr. Willis certainly not to be confessions by any stretch of the meaning. At most, they'd be deemed admissions under the corpus delicti rule. I'm cognizant of the law in that regard as well. So Mr. Willis to Corporal Hare did admit that he knew Jessica Heeringa. He indicates that he arrived home at 9:45 p.m. on the night of the disappearance of Miss Heeringa and remained home until 12:30 p.m. the next day, that being April 27th of 2013. That's significant when considering the testimony of Investigator McDonald and the phone records, and I'll get to that in a moment. Corporal Hare indicated, in my mind, of significance that the van was checked. It was very clean. There were vacuum lines in the carpet. And that Mr. Willis indicated that the van was purchased and it was not detailed at the point of sale, but that it was detailed by him because he just bought it. And whether or not a used car is sold undetailed is up for debate. But what's significant to me is that Corporal Hare indicated that the van smelled of cleaning agents. What's significant to the score also is the testimony of Deputy Foster, in that Deputy Foster investigated or participated in the investigation of the murder of Rebecca Sue Bletch, and that Miss Bletch was shot in the head and had bullet wounds to her head that were ultimately deemed to be the cause of her death, and that at the scene of the Bletch homicide there were .22 caliber shell casings in the southbound lane of travel. Deputy Harris also found additional shell casings, I believe 2 additional shell casings, from the one found by Deputy Foster at the scene of the Bletch homicide. And that Miss Bletch was deemed to have been murdered by a gunshot wound. Also of significance to the court Also of significance to the court is the testimony of MJN, the minor young lady who testified as Mr. Hostica and Mr. Hilson articulated. MJN testified that she had been out some time walking after being disoriented and lost on the north end of the county, that the defendant, who she identified, pulled up in a silver minivan. She asked to use a cell phone, and she had to get in the car to use it. You don't have to get into a car to use a cell phone. That immediately when she got in the car, I'm just going to call it the way it is. That's an abduction. That is what this court sees this. The doors were locked in the car. He started to pull away and went in a direction of travel that was contrary to MJN's desire and did not stop his vehicle when he asked. That, to me, is an abduction. And it's important to note that. I have to call it the way I see it. It's important to note that when we consider what's being alleged as to the kidnapping charge with respect to Jessica Lynn Heeringa, that she had a gun pointed at her inside the car and outside the car. That is an abduction. She identified a basket with netting in the car. She jumped out of the car moving to the degree that it caused, in my mind, significant injuries to her arm, to her shoulder, to her buttocks, to her back. She ripped a fingernail off. She ran out of her shoes. That's how affected she was by this. And she identified the defendant as the individual that committed these acts against her. I find her to be a very credible witness. I find the use of the cell phone, or the offering of the cell phone, was a ruse to get her into the car, because then the car doors were locked. Deputy Jeff Blackmore testified that in relation to the MJN abduction and that investigation, that the shell casings were recovered. I actually at one point took a look myself at those shell casings, or at the live rounds at the scene of MJN, the MJN attempted abduction, and I saw no corrosion. I saw them not to be weathered. They looked like they may have been run over by a vehicle, but I didn't see them being weathered. And what I also know is that they are CCI brand manufactured, consistent with the same manufacturer and caliber found at the Bletch homicide scene. And considering the testimony of Detective Matt Schultz, and I consider Detective Schultz's work to be very good police work. Based upon the description given by MJN and the video seized from the Blueberry Farm, and with the work of the Secret Service and all of the law enforcement in this case, they were able to narrow the pool of cars from 1,000 to 30 to 10 vehicles, Mr. Willis's vehicle being one of those 10. It's commendable. It matched in color, and the antenna was a narrowing characteristic. in a unique rust area found Mr. Willis's van was identified, and he was identified being Mr. Willis by MJN in a photographic lineup and in court here. It's also significant to me that during the course of this investigation, 2 handguns were found associated with Mr. Willis in a number of searches of his vehicle and his home on Sheridan Road and his family member's home in Bailey. And 2 handguns were associated with him. One was a .380 caliber handgun that was registered in his name, and the other was this Walther P.22 caliber pistol, not registered in his name, but registered in a co-worker's name. And in no search, which was very thorough, finding, they did it thorough enough in the home where they find a hard drive Velcroed to a stud underneath a cold air duct return, a cold air return of a duct. They found no airsoft gun, they found no fake or toy pistols. The court also considers the evidence that in the abduction of Jessica Lynn Heeringa, and from that point on, the common thread here is this P22 Walther handgun and its accessories, and the bullets and shell casings found throughout the course of this investigation, all matching caliber and all matching manufacturer, that being a CCI brand caliber. That's significant. As to the court's finding with respect to whether this was a death and whether this death was caused by criminal agency and whether the kidnapping of Jessica Lynn Heeringa was for the purpose to engage in criminal sexual penetration and criminal sexual contact or criminal sexual contact, the court finds it important to consider the evidence found, which I would characterize as being intrinsic evidence under People v. Jackson, not 404B evidence, not other acts evidence, but intrinsic evidence in this case, the fact that the allegations involve a restraint with intent to commit sexual penetration or sexual contact, and Mr. Willis's van was chock full of restraint items, handcuffs, ropes, restraints, ball gags, J-hooks, leather straps. That's significant to me. That's intrinsic evidence of an intent to engage in criminal sexual penetration. And dildos and lubrication and rubber gloves. If the allegation is an intent to commit sexual penetration or criminal sexual contact, then I find that evidence to be intrinsic on the matter. Detective Sergeant James McDonald testified that he's an expert in the area of, get this right, cell phone analysis. He testified that at 12:05 a.m. there was an outgoing call to the defense phone from the Willis home. And that started at a tower west of 31. It encompassed the Bailey Street address and absolutely showed that the defendant's phone was not on Sheridan Road, and I think his words were absolutely not on Sheridan Road. And to me that's significant because it's contrary to what the defendant said happened when he was interviewed by Corporal Hare. What's significant to this court is that the Walther P.22 caliber handgun had the serial number defaced or obliterated. That evidences an intent to at least hide the genesis of the handgun. And if there's no nefarious purpose, you don't obliterate serial numbers on handguns. It must be said that this court considers the homicide of Rebecca Sue Bletch to be tied to the defendant, and it's important circumstantial evidence when I consider the paramount question before me on the open murder charge of whether Jessica Lynn Heeringa is dead and whether that death was caused by criminal agency. The tying of the Rebecca Bletch murder to Mr. Willis is significant in that regard. According to the ballistics analysis, of which I find to be a verifiable science, the bullets taken during the autopsy of Rebecca Sue Bletch and the shell casings found at the scene of the Bletch homicide match the gun found in the van operated by Mr. Willis, which has his DNA or DNA profiling match on the trigger and on the barrel of the gun. I also find it significant that DNA profiling by the star mix method on gloves found in the vehicle a year after the Bletch homicide have a DNA profiling match, at least according to Ms. Schmidt, that is a mix that matches Rebecca Sue Bletch and the defendant. Why her DNA would be found on a pair of gloves in Mr. Willis's car only points in one direction for me. It must be noted that in People's Exhibit number 91, the laboratory report authored by Michelle Schmidt and admitted as evidence in this case indicates that there is a mixture of DNA found on what is described as a dildo slash vibrator found in the defendant's car that suggests a mixture of DNA and that mixture of DNA includes Rebecca Bletch. That's significant to me when I have to consider whether there was an intent to commit criminal sexual penetration with respect to Jessica Lynn Heeringa. What's also significant to me as a fact finder in making a probable cause determination is People's Exhibit number 86. It's a hard drive that had to be released from a stud in a cold air return, and that it was a backup, or similar to a backup hard drive that was in, I believe, a dresser drawer. That evidence is an attempt to hide that hard drive. And what was found on the hard drive were documents titled VIX which included identifying characters consistent with Rebecca Sue Bletch, RSB, and the date of her death, which we know was June 29, 2014. Also, that hard drive contained passwords identified with Jessica Lynn Heeringa, and a folder under the VIX portion of the hard drive with Jessica Lynn Heeringa's photograph, newspaper clippings, and the date of her not disappearance, 3/26/13, but the next day, 4/26/13, but the next day, 4/27/13. It's more than a coincidence in this court's mind that the day after the alleged abduction is the date that Mr. Willis had identified on the password and in the hard drive that's consistent with the day we know Rebecca Bletch was murdered. That's no coincidence, and I can't ignore it. What I also found to be significant and relevant as to the homicide case, and this would be certainly deemed to be extrinsic evidence under People versus Jackson, where the 5-page document contained in People's 88 a list of serial killers in the United States. It was 5 pages of what I would say is certainly not 12-point font, it's 6-point font. And it's a 5 pages listing line for line for line for line of serial killers in the United States. And I find that to be circumstantial evidence that the disappearance of Miss Heeringa resulted in her death, and that the disappearance of Miss Heeringa was due to criminal agency. I find it relevant on that fact. I also find relevant the testimony of Detective Sergeant Zach Sparks, People's Exhibit number 90, outlining a list that included a kit, and it had the word kit blocked in, and it outlined a list that matches the items found in the defendant's van. And again, I find this relevant as to finding that there is corpus delicti, that Jessica Lynn Heeringa is deceased, and that it was done by criminal agency. And I find it circumstantial evidence of an intent to engage in criminal sexual penetration and sexual contact. And I likewise find to be relevant the testimony of Specialist Gerald McCarthy in his forensic analysis of electronic media, in this case, computer towers and hard drives. And I find it relevant, as I said earlier, that a new password was created accessing files or folders or information and the list of bank informations and websites and usernames and passwords, all with a new password of J4L27H13. I also find it relevant as to corpus that there were abduction, rape, kill videos, several hundred of them found on the defendant's computers, found and taken from his home, that these videos depicted kidnapping, abduction by force with weapons of varying kinds, including handguns, including people out for walks and jogs and at their businesses, that these victims in these videos were restrained with ropes and chains and handcuffs and tape and ball gags used, all consistent with evidence, physical evidence found in Mr. Willis's van, that these victims in these videos were violently sexually assaulted, tortured, and all resulted in death. I find that to be relevant evidence as to the demise of Jessica and Heeringa and the intent of the perpetrator with respect to criminal sexual penetration and sexual contact. I also find it relevant that at the Bailey Street address, there were cleaning products, including Tide with bleach and 4 Clorox bleach bottles, all dated with date of manufacture after the abduction of Jessica and Heeringa. I also find it relevant that the address on Bailey Street where the bleach bottles were found had no washer in the basement or upstairs. I've already talked about the testimony of Ms. Schmidt and the finding that there was strong support for Rebecca Bletch to be a contributor on the gloves and strong support for the defendant being a contributor of the DNA on the gloves. I've already mentioned that, as well as the dildo/vibrator. I find the testimony of Michelle Snantala to be relevant in this matter and relevant in an intrinsic sense under People v. Jackson. I'm not using the word res gestae, that's outdated language, but I find the testimony of Michelle Snantala to be relevant and intrinsic as to these charges before this court. The allegation is that Ms. Heeringa was murdered with a handgun, evidenced by the laser sight and the batteries and the blood spot found at the rear of the Exxon station, and the origin of the gun and its ultimate finding and everything in between, in my mind, is intrinsic evidence and relevant and should be admitted in this case, and that was my ruling, but I'm reiterating that for any future review. Also relevant circumstantial evidence is the testimony of Clifford Barron that on the Sunday after the disappearance of Ms. Heeringa, Mr. Barron observed the defendant, Mr. Willis, at work, and he had injuries to his right hand, left forearm, and face. In my mind, that would be consistent with a struggle